Good morning, good morning, good morning, and hear ye, hear ye, hear ye. We are here today together on this Friday, June 13th. It is the day for closing arguments. The court had told everyone to be prompt this morning and on time and ready to go, had called the jurors and asked them to come in early and wanted to start closing arguments promptly at 9 a.m. Eastern Standard Time. There were 31 days of evidence, 8 weeks, and the court granted the attorneys an extra 15 minutes for closing. So we'll see how that goes. And yesterday I had talked about the normal process for closing arguments. However, I forgot that nothing is normal in Massachusetts and that closing arguments are not prosecution, defense, prosecution, rebuttal. They are defense first and then prosecution, rebuttal. I have wiped it from my mind that it's just the one and then the one, but we will see the defense go first and then the Commonwealth. The court will do a few opening instructions to the jury. Then they will hear from the lawyers. Then there will be a quick lunch break. Then the court will read the hour of closing arguments, and then the jurors will go back to deliberate. The court had asked if they could stay late today for deliberations. So make sure you have the Law and Order app, because I will let you know when we know something or if something happens in court or if we are going live.
There was no collision. There was no collision. There was no collision.
Go
you
read
weren't
them.
given the opportunity to hear from Michael Proctor, but you can read his thoughts for yourself.
Ding, ding,
and I
ding.
urge you, go read them. They're in Exhibit 209, 209, in case you're wondering. But here are the highlights. Proctor starts the conversation.
You didn't hear from Proctor. Go read his texts. They're number 209. Yeah. Sit down and read them. Read them all. Because nobody called him to testify. A excellent point and a great way to keep highlighting to the jury they never called Proctor.
Quote, all the powers that be want
me.
answers ASAP. He's getting pressure, obviously. Get this done. His friend then asks what Proctor's probably thinking at the time. Quote, I assume you guys are out to make it cut and dry since it involves cops. Something stinks.
These are the texts.
And Proctor responds, yeah, to the something stinks. And then he goes on, but there will be some serious charges brought on the girl. Think about that. Hours into this investigation, there will be some serious charges brought on the girl. She's a whack job.
Oh, damn.
Yeah, she's a babe. Weird Fall River accent, though. No ass. No ass bitch. She's got a leaky balloon knot. Leaks poo. 0 chance she skates.
Well,
she's fucked.
Shit's out of the horse now.
And up to this point, Michael Proctor had done 0 investigation. Nothing. But their own witnesses contradict that. Jennifer McCabe admitted on cross-examination that her very first statement to law enforcement, confirmed that Karen didn't say anything. She asked, could I have hit him? Did I hit him? Is he dead? The physics and the science answer that question. Could you have hit him? No, you couldn't have. Sergeant Buchanan also testified that the only statements Karen Read made at the scene, according to his conversations with the first responders, was, could I have hit him? Did I hit him? It wasn't a confession. It was confusion. And Dr. Russell explained that confusion. She told you why Karen Read or anybody in that position might ask those questions. She was suffering from extreme grief reaction, which according to the evidence can last for years. Even her medical records confirm that diagnosis. It's common to ask those questions in grief.
That's not
It's
evidence.
common to ask those types of questions in shock. You're trying to make sense out of the nonsensical in the moment. And the Commonwealth has tried to twist those words into a confession. There is no evidence.
Remember, that answer only came in from Dr. Russell because Brennan kept pushing on cross. If the defense had tried to elicit it from Dr. Russell, it would not have come in. That came in because of cross-examination from Hank Brennan. They did not hear it last trial, but they heard from Dr. Russell that there's a reason that would explain the things Karen Read said and why. And we knew they were going to use it in closing.
That any officer at the scene ever heard Karen Read say, "I hit him." Not a single police officer at the scene came in to support the Commonwealth's claim. It's not on video, it's not on audio, it's not in a single police report, it's not in a single EMT or EMS report. Nowhere. The fact is, Karen never said, "I hit him." You saw the video. Multiple officers were right there. She simply never said it. Then we get to the sweatshirt.
Yep. Hoodie next. It was a bridge too far.
Mr. Brennan stood here in front of you and dramatically held up John's sweatshirt. Not just to the witness,
It's the order I would have argued it into.
but to you. And asked Dr. Wolf about it multiple times.
Here.
Specifically, while it was in that plexiglass, asked Dr. Wolf about the multiple holes in the back of the sweatshirt. He interrupted Dr. Wolf, and Dr. Wolf started to look at the sweatshirt and say, "Well, and he said, "How about here? Here's a hole, here's a hole, here's a hole, here's a hole," dramatically tapping on that plexiglass. It was clear what the suggestion was, that the holes in the back of John's sweatshirt were from January 29th. That's the impression that was expected to be left with you. That's the impression that he wanted to leave with you. And that's false. The truth is, the Commonwealth created those holes. They aren't holes from road rash. They weren't made on January 29th. Those are cuttings from the Commonwealth's own crime lab, folks. That's what those holes are.
The court told you.
And even with 3 prosecutors, all 3 of them, sitting right there in the room at the time, it had to be the defense to correct that record, to bring out the truth. If we hadn't done that, what impression would you folks have been left with? That's more than negligence. That's dangerous.
Oh boy.
It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this, about the fraud that was attempted on you. And if he doesn't, that speaks louder than any concocted excuse that the Commonwealth might come up with.
Oh
It's
boy.
shameful. It's shameful. We are after the truth in this courtroom. You're entitled to it.
I'm not going to be able to take you seriously if you start yelling you can't handle the truth. I'm just putting that out there now. However, he has challenged Brennan to explain himself. Brennan wrote his closing last night or the night before, I'm sure, but he has challenged Brennan to explain himself. We'll see if he does.
Demand it. Why would the Commonwealth stoop to a stunt like that? It's desperation. They know what you now know, what their experts know. There was no collision. Don't let them get away with this. Do not endorse and sanction an investigation that is broken and corrupted top to bottom. But just as importantly, do not let Michael Proctor get away with it. And make no mistake about it, folks. If you convict Karen Read of anything, if you convict her of anything, science, the physics, the data, they lose. But tragically, Michael Proctor wins.
Strong.
Remember
point.
his texts.
Oh.
Something stinks.
Oh dear.
Yeah, but serious charges will be brought on the girl. She's fucked. Could you ever say to yourself, this is justice? The fact is there was no collision. A car did not kill John O'Keefe. So I ask you, Let your voice be heard, not in whispers, but in truth. Let the community feel through your verdict that justice cannot be bent.
That's close.
And that it will not be buried.
A little close.
Find Karen Read not guilty, not guilty, not guilty.
That's probably the end.
Thank you.
Yep. That was a powerful closing argument by Jackson. He used the Commonwealth's I hit him to bring no collision, no collision, no collision. And at the end, not guilty, not guilty, not guilty. When I was saying at the end, that's a little close, bringing in the community and other things gets really on the line to improper argument. But I'm not surprised that Brennan didn't object right at the end of closing. I think it probably would have pissed people off in the courtroom and the jury more than the objection was worth, because it was so close on that line of improper argument. But I think saying let your voices be heard ties it in. The community deserves to have faith in the system. Again, close. But if that is the only criticism of closing, it is a minor one, because Jackson has done this a very long time. We know that he leans in to storytelling, to showing the jury. And we didn't see all of their PowerPoint, but we know from the parts that we saw that there were index cards with his points on them dropping on to stacks of reasonable doubt. He opened with the burden, he ended with the burden, and he told the jury what he wanted them to do with that not guilty, not guilty, not guilty at the end. He didn't go into the specifics and nuances of the jury instructions because it goes against his argument. His argument to the jury is this is so obvious, there is so much doubt that it doesn't matter what the jury instructions say. It doesn't matter what the verdict forms say. The only option here is a not guilty verdict. And he called out Brennan directly about the hoodie. He called out Proctor over and over and over again. And we're going to go to Brennan's closing now, but my takeaway on this closing versus last closing, and I did not go back and rewatch it. This is my initial takeaway. Focusing on the investigation, I think, was so much more powerful than focusing on Albert this, McCabe this, who did this, what phone went there. He focused on what the investigation didn't look at, who turned the other cheek, who ignored what they could investigate, and what the Commonwealth didn't show you. It does not ask the jury to believe that all these people did a thing. It asks the jury a very simple question. Do you believe that you know the truth? Do you believe that you were shown everything in this case? And do you believe this was a sufficient and thorough investigation? And if you do not believe those things, then you cannot come back with any other verdict. Focus on the investigation, the investigators, and what the Commonwealth didn't show. I think it was a much more powerful closing, and it gives the jury a cleaner task. Do you believe it? Do you trust what you've been shown? Can you trust this investigation? And can you trust Karen Read's words? I saw a lot of you in the chat, and there's over 60,000 of you in the chat saying, is he going to address the clips? He did with Dr. Russell. It was sandwiched there in the middle, but he's not going to highlight those clips. He tried to undermine Karen Read's words being a confession by saying, was it a confession or confusion? That's how he undermined it. That's all. Brennan is going to lean into Karen Read's words quite a lot. But in opening, Brennan said he was going to lean into the science and the facts. Let's see what he does.
John O'Keefe was 46 years old. 46 years old. He spent his life helping people. He's described as a good man, kind, generous, thoughtful. He was a Boston police officer. He worked to help the community. The healthcare data on the phone shows that John O'Keefe is not moving. The car is stopped at the flagpole. The healthcare data stops. The battery stays at 77 degrees. The data is the data. You can't change it as much as you want to. It's data. And they sit at that flagpole for minutes. It's 12, 24, 33 when they get there. They're there past 12:30. Remember, Ms. Mason and Ms. Nagel said they were there about 5 minutes and then they go? It's not exact, but about 5 minutes, they said. So there's about 2 minutes left for John O'Keefe. And what are they doing in those 2 minutes? What are the last 2 minutes of his life that he can remember that would be open to him?
Oh, boy.
They're arguing. They're arguing. They're arguing. And we know they're arguing because Ms. Read tells us through first responder Becker. She was sad. Remember, he sees her in the back of the ambulance and he's trying to calm her down? She was sad because her last moments were arguing. They're in an argument. That's why they're not going in the house.
That also supports the stress, though.
But John O'Keefe decides to get out of the car, and we know because the dome light goes on. That's what happens when you open a door. Whether he's bent down, he's standing outside, or on the other side, the dome light is on. And then you see the data. John O'Keefe begins to move. 12:31:56. It's the first time he has moved since they got to the flagpole, and it will be the last time he moves in his life. And he moves for 20 seconds. Ian Whiffen said that the satellites, they move, they reconnect, they pull information. He's no longer on high-frequency data because waves are shut off. Now it's more random. It's low-frequency. We would never suggest, and Mr. Whiffen did not claim, based on location data alone at that point, you can tell exactly what John O'Keefe is. What he said is it was readings all night. The bullet is always near the flagpole. That doesn't mean he was always near the flagpole. He could have moved. He could have moved in the circles and come back. Location data is consistent with him never leaving the flagpole.
What?
That in and itself is not enough.
He could have moved within the circles?
There is more. There is the healthcare data.
Wait, what?
There is the temperature of the cell phone battery. And so he moves for 20 seconds. It turns west. It does not say he walks to the house. That's not what the data says. It doesn't say that he goes straight line and he walks over to the door. In fact, could he even get to the door in 75 feet? Could he get there? Because when the investigator for the defense testified, he measures from the driveway. He never stopped at the driveway. He never measures from the flagpole. He never measures from the flagpole to the garage door. So this fantasy that somehow he walked in the garage, even though there's no evidence, there's no witness, there's no data. 20 seconds of his life, and he moves. And healthcare data registers his steps. It could be pacing. It could be a straight line. It could be shaking the phone. We don't know.
We don't know.
We don't know everything. We don't know every little detail and every little second. We don't have to. That's not doubt. That's not reasonable doubt. We know for that 20 seconds he's moving. And in that 20-second window, when he moves, he has his phone and he looks down, 12:32:09, he sees a text message from his friend, Jen McCabe. And he looks at the text message and he closes it.
I don't think I've ever heard a prosecutor say we don't know everything and we don't need to.
We know from the uncontroverted data from that black box, we know that Karen Read, after he gets out of the car, drives away. She drives for at least 33 feet away from him. He's back near the flagpole. She's gone. It's over. Whatever argument is over. Whatever anger and flame has been dispassioned, she's moved on. He's separate from her. He's safe. And then she makes a decision. That's what this case is about. Then she makes a decision. She could have driven home. She could have broken up with him. They could have talked about it the next day. or like knocking on the door, like Kaylee said, getting the last word. She doesn't drive away. She takes that 6,000-pound Lexus and she makes a decision. And the decision is that she steps on the gas after banging it into reverse. Are we on a conspiracy? Or is it that these good people who went there for a total stranger to do their duty to help happen to remember that she admitted what she had done? I know that doesn't reconcile with the Boogeyman Proctor and the bad government. I know it doesn't reconcile with no DNA on this piece of that.
Did he just call Proctor the Boogeyman? Okay. We've heard Proctor's name once. He's not explained what Proctor did. He's not explained why this investigation's not tainted. But he said, essentially, the defense is making Proctor the Boogeyman.
No DNA on this piece of that piece. I know it doesn't reconcile with everybody setting up the girl. I know that doesn't reconcile. But the reality is, you have independent, core people who hear her say, I hit him. I hit him. We don't know if this is the body position. We don't know if this is the exact speed, but what it tells us, this is viable. Look at the debris field. Look at his turn. Remember his sneaker on that curve that got lodged against the sneaker? Mr. O'Keefe then falls back, hits his head, counter coup, left to die. Ladies and gentlemen, there is no doubt what happened that night. There is no doubt who did it. You have a very difficult task ahead of you when you consider the evidence and you consider the law. Very difficult. There are 3 charges. There is second-degree murder. Ms. Read, when she chose to drive back at Mr. O'Keefe in that night with a 6,000-pound Lexus, in that anger, 75%, whether she meant to hit him or not, didn't mean to kill him, she hit him. Straight, it is a plain and strong likelihood of death. You would never get back down your driveway if your kids were at the end of the driveway. You would say, well, you're going to kill somebody? You would never do it because you would expect, if you drove at them at that speed, that someone would die. That's second-degree murder. OUI manslaughter, she's drunk, she was reckless. She doesn't even have to know she hit him. She doesn't even have to know she hit him. But she did. She did. And she left a man who was kind and generous and thoughtful. She left him alone. She left him alone to die. Could I have slide 22, please? He is not an it. John O'Keefe is not a body. John O'Keefe is not a buffalo on a prairie. John O'Keefe was a person, and he was murdered by Karen Read.
The Commonwealth just finished their closing argument. I'm very surprised at how they ended their closing argument. I thought that they would end with Karen Read's words from her. They didn't. They ended with a photo of John O'Keefe and then quoting and paraphrasing some of Karen Read's words. But what surprised me is that in most cases, you will see the prosecution at the end say, and we are asking you to find the defendant guilty of count 1, 2, and 3, or whatever the counts or charges are. We thank you for your time, your consideration, your diligence in this. I know it's been a long trial. He did not thank the jury once, which actually surprised me. There were points of Brennan's closing that felt like he was arguing from the perspective of the defense. It's the job of the prosecution to close all the loops. And as he showed the ARCA video, the 24-mile-an-hour test, because Chad is Bay and reminded me that's not the 29-mile-an-hour one because that's the one where everything got wrecked. The 24-mile-an-hour test, he said, this shows you that it's viable. The standard in Massachusetts is proof beyond a reasonable doubt and to a moral certainty. There were points that he made for his closing that were good points. The points about John O'Keefe's cell phone, the points about the data. But one of my criticisms of Hank Brennan is there's times where his really good points get lost in the other stuff. And we will see if his good points get lost in the other stuff. Because I think he said Jen McCabe was a soccer mom 4 or 5 times. He did talk about Trooper Proctor more than I thought he would. But he essentially called Trooper Proctor a distraction and said, well, Trooper Buchanan came in here and told you this investigation was not compromised, that this investigation had integrity. He didn't say Trooper Proctor was honorable, but he said that this investigation had integrity. And Brennan argued, look, I didn't put in the parts of the taillight that Trooper Proctor found. I didn't. I know what the texts are. I didn't. I'm not defending those texts. They're not defensible. The defense put those in. Yes, he absolutely argued that in his closing. But he talked about John O'Keefe's cell phone, when it stopped moving, the location data showing that John O'Keefe's cell phone did not move. He called it the healthcare data a million times over and said that the healthcare data shows when John O'Keefe's phone stopped moving. And he argued that the battery temperature went down commensurate with being outside and then slowed down commensurate with being underneath John O'Keefe and then went down again more rapidly when John O'Keefe was taken by EMS. I thought those were helpful points. He talked about the debris field being the same as you saw on the ARCA crash tests. But he also said that the ARCA crash tests proved that it happened the way he said it did. He said, thank you for that. But earlier he said the reason Dr. Welcher didn't do crash tests is because there's not enough information to do those tests. He argued that the testing by Dr. Welcher didn't say that's exactly where John O'Keefe was. It was almost like he was arguing that the Welcher testing was to show that it was possible, but not to show what happened. And I think that's where, for Brennan, the facts are difficult to argue. I also said it in the middle of his closing. The defense, I think it was in the first trial, talked about the prosecution wanting you to look the other way. And Brennan took that into his closing this trial and said, the defense wants you to look the other way. It's a dog, it's this. There's no evidence of that. At one point, he said they don't have evidence of that, which I think is objectionable. I don't know if he said it more than once, but he kept saying there's no evidence of that, but insinuating there's no evidence of that towards the defense points. The defense doesn't have to bring evidence of anything. The defense can just poke holes. Here. He didn't address John O'Keefe's hoodie, but there were times in the prosecution's closing where it seemed like he was writing his closing towards the way the defense argued the case in the first trial. He kept saying there's no conspiracy here. He said it over and over. The defense didn't argue a conspiracy this trial. The defense said, look at all these things that law enforcement didn't look at, which we've been talking about together for 8 weeks was going to be their closing. They've said it in court and in their motions. They said they were going with the Bowden defense, and that the Bowden defense was, look at what law enforcement didn't look at. It's spelled out. Look at what law enforcement didn't look at. Look at this behavior. They didn't investigate it. Look at this behavior. They didn't investigate it. There were points of Brennan's closing where he made very strong points about the phone. The problem for me with Brennan's closing is that he didn't close all the loops. This is viable. This isn't a conspiracy. He leaned in very heavily to Karen Read's words, and we knew he was going to do that. She said it. He took his points and then highlighted it with Karen Read's words. This is what she said. This is what she said. This is what she said. And he took the time to explain count 1, 2, and 3. He took the time to explain the actions that he thought were wanton and reckless for count 2, something that was never explained in the first trial at all, and something the defense did not spend time on. The defense spent time on, we're not even going to explain this to you because there's no collision, therefore there cannot be a guilty verdict. The prosecution leaned into, listen to what Karen Read said. Listen to how she talks about John O'Keefe. She backing up the car. That is the wanton and reckless behavior. That is the volitional behavior. And he leaned into the text stream data and pointed out that the defense experts did not come for the text stream data. They came for Welcher's paint test. Did the defense poke enough holes? Did the prosecution close the loop? The reason the prosecution goes last is because they have the burden. But I feel that Brennan didn't shift his closing to address some of the points that the defense made and the tenor of the argument from the defense focusing on the investigation. He kept arguing against a conspiracy that the defense didn't argue. They've talked about it outside of court. They talked about it a lot last trial. They went to points of it. The defense barely talked about Jen McCabe. And they talked about it in the context of what investigators didn't look for. And Brennan, I don't know if he did enough to circle it back around and say, investigators didn't need to look more. Investigators didn't need to look more because the evidence is so clear. He did not argue that. He did not argue about the investigation other than to say, Proctor's a distraction, look the other way. It's all a big conspiracy. Interesting strategy from Brennan. But it was also interesting that he said the defense was leaning into emotion in their closing, which both sides did. Closings should be a bit emotional. The defense leaned into emotion in their closing. He started with emotion in his closing, and most of his closing was about emotion. And I think the jury's going to sit there and being like, wait a sec, what? Who's talking about emotions? Because the whole time. The jury is out. We are on verdict watch. That is where we're at. Let's talk about what happened after the lunch break. It seems that the jurors got a quick break. The court reminded the jury that they normally do not take a verdict between 1 and 2 p.m. That ship is kind of sailed because it is 3 p.m. local time. The jury is out to deliberate. The court read in all of the jury instructions. What I was curious to see is, would the court give the instruction the defense had asked for regarding the discussion of John O'Keefe's hoodie? The court did not. The other thing I was curious to see is if the court would include just a DUI in the lesser includeds. And yes, the court did include a DUI in the lesser includeds. I also saw a lot of confusion over lesser includeds. The lesser included crimes to be included on the verdict slip must be crimes where all of the elements are also included on the greater charged crime. So it is saying that there is the top crime, and then in those elements, there are also these lower or lesser crimes. They are less serious crimes. So the most serious one is charged, and then you can add the less serious crimes under it. And that is what was done here. The same few as last trial, plus the addition of a flat or a straight DUI, just a driving under the influence. So count 2 now is count 2, the manslaughter while driving under the influence, then lesser included A, involuntary manslaughter, lesser included B, motor vehicle homicide, and lesser included C, DUI. I think I got all 3 of those correct. The lowest level charge on that, the DUI, is going to be a misdemeanor DUI, just a drinking and driving, which I imagine a first time misdemeanor DUI is going to involve fines and alcohol classes and maybe community service and maybe probation. And that's about that. So those are the lesser included. Yesterday in the charging conference, you heard Attorney Lally say he was not asking for a lesser included or any lesser included, and the defense said that they were. There are some charges, and I don't know if this is the case in Massachusetts, there are some charges where the lesser includeds get added automatically. So even if you have this greater charge, that the lesser includeds are automatically given to the jury. It is not adding charges. It is not asking for more charges. It is giving the jurors options A, B, C, D, E, because all those elements are in that greater charge defense. And the attorneys know that. And it's one of the things that attorneys talk to their clients about and strategize about if they want lesser included. If they don't, sometimes the judge will add them in there without the attorneys wanting them. It really just depends on the case, the judge, the charge, and the jurisdiction. But Attorney Lally said, we're not asking for lesser included. The defense said that they were, and the lesser included were in there.
All right, jurors, I understand you want to go home. It's been a long day for us. We appreciate everything you've done today. I do have to tell you those same cautions. Please do not.
Did you hear what she said? I understand you want to go home.
Discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Do not talk to anyone, and that includes each other. So when you walk out the deliberation door, you have to stop talking about this case. Even when you come into the courtroom, don't mutter anything to each other, certainly not on the ride or anything like that. So it's very important that you remember that. And you cannot, even if you get here before you're called into court on Monday, you can't discuss the case then either. And that goes for the alternates as well. So, we really appreciate that. Watch your social media use and the papers and the news. Stay away from all of that if you can this weekend. We'll see you Monday morning ready to start out fresh. Thank you.
All right. And with that, the jury is gone for the weekend. The jury will not be deliberating over the weekend. The jury was like, can we go home? I am sure they are exhausted. It is a lot to think about. All right, the court's coming back on the record.
All right, well, I hope everyone has a good weekend with no work.
Thank you.
Have a good weekend. At the end of the day, it seems that the jury asked if they could leave just before 4:30 local time. The jury went out to deliberate just after about 2:39, according to Ted Daniel, local time. So they were out for a little under 2 hours, and they will be back Monday. So I will be on a very close verdict watch for Monday. Remember, they do get that very strong admonition. Don't just take a straw poll. Go through the evidence. Give it a thorough look. I am sure the jury is tired. I don't blame them. And it might well be that they want to take the weekend, sit on it, and come back and talk about it on Monday. Because I'm sure they're tired. I am sure it has been a long day. Lots of starts and stops. So the jury said they were ready to go. They are ready to go. I think that it wouldn't be surprising if they said, hey, we're probably not going to be able to come to an agreement on this tonight. It's a lot of shit to go through. Let's just come back Monday. So that doesn't surprise me at all. And she told the lawyers, have a good weekend. No work if you can manage it. So jury verdict watch is done for the day, because the jurors are done for the day. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.